Mr. President, members of the Court, it is an honor to appear before you on behalf of Islamic Republic of Pakistan in these most important of proceedings. These proceedings take place as a whole people struggle to survive through relentless bombardment. The very people who have endured daily persecution for over half a century. And yet, these proceedings inspire hope. They inspire hope because they present an opportunity. They afford this court an opportunity to develop jurisprudence, to advance essential principles of international law that preserves and advances the very basic human right of liberty and dignity. Pakistan has always been a defender of the Palestinian people and their right to self-determination. It was Pakistan that proposed the General Assembly's first resolution on the first day of the Six-Day War relating to Israel's invasion of Jerusalem and the measures taken by Israel to change the status of the city. Since then, Pakistan has continued to engage on these important questions of international justice, and it remains committed to contribute and play its part. Against this background, I will deal initially with 5 points and then make some technical legal arguments that Pakistan considers to be of particular importance in these proceedings. First, the question of self-determination. Second, the question of occupation and annexation. Third, systematic racial discrimination and apartheid. Fourth, the question of City of Jerusalem and its holy places. And finally, the two-state solution. Mr. President, members of the Court, I come to my first point. The Palestinian people have, as the Court itself has recognized, the right to self-determination. This right, which is codified in the two United Nations Human Rights Conventions, is one of the essential principles of contemporary international law. All states have a legal interest in protecting that right, which has the status of jus cogens. Israeli measures that severely impede the exercise by the Palestinian people of the right to self-determination are in breach of Israel's obligations to respect that right. Pakistan strongly believes in the inherent right of people to live freely and in the justice of struggle for freedom from alien subjugation under the right of self-determination. I turn to my second point, the question of Israel's occupation and annexation. It has always been the position of the United Nations that it, and I quote, cannot condone a change in the status juris resulting from military action contrary to the provisions of the Charter. The organization must therefore maintain that the status juris existing prior to such military action to be re-established by a withdrawal of troops and by the relinquishment or nullification of rights asserted in territories covered by the military action. End of quote. Thus, after the Six-Day War, the Security Council determined in Resolution 242 of 1967 that Israel must withdraw its armed forces from territories occupied in the recent conflict. In Resolution 476 of 1980, the Security Council reaffirmed the overriding necessity for ending the prolonged occupation of Arab territories occupied by Israel since 1967. Israel's occupation is no longer, if it ever was, a military occupation. It is annexation. In East Jerusalem, the annexation is de jure. In the rest of the territory, it is de facto. But the formal characterization matters little. To use the words of the court in the Wall case, the occupation is today, and I quote, notwithstanding the formal characterization, tantamount to de facto annexation, end of quote. This now applies to the entire territory. This may have been the intention all along. Prime Minister Ben-Gurion affirmed in 1950 that, and I quote, the Israeli empire must comprise all the territories between the Nile and the Euphrates, end of quote. And this was to be achieved as much by invasion as by diplomacy. More recently, Prime Minister Netanyahu has declared that his government will be, and I quote, applying Israeli sovereignty over all the communities formed through the transfer of Israeli settlers, and not one resident or community will be uprooted, end of quote. Through its settlement policy, Israel has sought to create irreversible facts on the ground. It has aimed to create physical facts, which in practical terms make it as difficult as possible to bring an end to its prolonged occupation, the West Bank and East Jerusalem. Notwithstanding, the Security Council has reaffirmed that the settlements constitute, and I quote, a flagrant violation under international law, end of quote. As this court said in the Namibia case, a binding determination made by a competent organ of the United Nations to the effect that a situation is illegal cannot remain without consequence. As in that case, in answering the legal questions now referred to it, the court is not concerned with the question of what practical steps would be required to seize the occupation. It is worth recalling, however, that even greater practical issues have been overcome in other contexts, such as when the French government withdrew 1 million settlers from Algeria in 1962. The French settlers were more numerous than the Israeli settlers in the West Bank and East Jerusalem taken together. France's settlements in Algeria were not only more numerous, they were also far older and better established than Israel's West Bank colonies. I come to my third point regarding systematic racial discrimination. Israel's policies and practices amount to systematic racial discrimination and apartheid. Israel has imposed a system of racial discrimination against the Palestinian people since 1967. It is a system that distinguishes deliberately and systematically along ethnic and religious lines between the Palestinian population and Jewish Israeli settlers illegally transferred into the territory. The purpose of domination and oppression may be inferred from Israel's pattern of conduct against the Palestinians. I turn to my fourth point, Jerusalem and its holy places. The holy city of Jerusalem is unique in that it is sacred to all three Abrahamic religions. Under the historic status quo, it is the right of Christian, Jewish and Muslim communities freely to access and worship at their holy places in the city. Ottoman decrees set out these rights in the 19th century. The regime was later confirmed in multilateral and bilateral instruments. The historic status quo has today developed into a so-called objective regime, which captures the point that it is characterized by a permanence which the instruments that established it do not themselves necessarily enjoy. Every state interested, therefore, has the right to insist upon compliance with this regime. Under Israel's prolonged occupation, Christians have not been free to access or worship in the Church of the Holy Sepulchre, and Muslims have not been free to access or worship at Haram al-Sharif and in the Al-Aqsa Mosque, to name only some prominent sites. The rights under the historic status quo must immediately be restored. This issue is of great importance to Pakistan, which is home to the second largest Muslim population in the world. And now I come to my final point of the first part of my statement. Pakistan believes that the two-state solution must be the basis for peace. In the Wall case, this court observed that the two-state solution was to be encouraged, and I quote, with a view to achieving as soon as possible, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of a Palestinian state existing side by side with Israel and its other neighbors, with peace and security for all in the region. End of quote. Pakistan supports this call. On 26th of October 2023, Pakistan was pleased to vote in favor of General Assembly resolution which reaffirmed that, and I quote, a just and lasting solution to the Israeli-Palestinian conflict can only be achieved in accordance with international law and on the basis of the two-state solution. 2 months later, on 22nd of December 2023, the Security Council reiterated its unwavering commitment to the vision of the two states, consistent with international law and relevant UN resolutions. And these and numerous other resolutions by the political organs of the United Nations make clear a two-state solution and negotiations leading to it must be consistent with international law. Negotiations, Judge Onal Khassani of this court observed in the Wall case, and I quote, are a means to an end and cannot in themselves replace that end, end of quote. He continued to say that the discharge of fundamental international obligations cannot be made conditional upon negotiations. In this regard, the court's advisory opinion in these proceedings will be most important. Far from impeding negotiations in the achievement of a just and lasting two states, the court's advisory opinion will further assist such efforts by making it possible for the parties to make progress on the sound basis of international law and international legitimacy. Mr. President, members of the court, I now turn to fulfill its own obligations cannot be recognized as retaining the rights which it claims to derive from the relationships." End of quote. South Africa had claimed it had an independent right to administer the territory by reason of its long occupation. Evidently, the court disagreed. 3 points follow from this. First, the court in Namibia case implicitly recognized that neither the fact of an occupation nor the law of occupation confer upon the occupying power any legal entitlement to administer the territory. Any contrary view would allow an occupying power to benefit from its unlawful use of force. Second, the court made a positive finding that South Africa's occupation was unlawful. In Namibia, there was a binding Security Council decision to that effect. The Security Council has made no such Security Council decision with respect to Palestine. But this in no way displaces or impedes the court's judicial function in determining this legal question for itself. Third, the court plainly did not consider that South Africa's continued status as an occupying power made any difference. As Judge Greenwood has explained, the basic position under the law of occupation is that an occupying power has the liberty to govern within certain limits without being guilty of violation of the jus in bello. The occupying power is required to administer the territory as temporary conservator or trustee for the benefit of the occupied population. Acting in that capacity, the occupying power has certain liberties to take measures in good faith, in the best interest of the occupied population, or where absolutely necessary to meet its own legitimate security interests. This, of course, is a separate question to the unlawfulness of the occupation itself. As to the position under the law of occupation, again, it is helpful to recall the Namibia case. The court's context-specific expression of the principle was that, and I quote, "a party which disowns or does not fulfill its own obligations cannot be recognized as retaining the right which it claims to derive from the relationship." End of quote. Pakistan considers that this has relevance when considering whether an occupying power should be recognized as retaining liberties to administer the occupied territory. In this case, if one were to zoom in exclusively on Israel's conduct as an occupying power, the only conclusion could be that Israel has disowned its basic duties. Its policies and practices of occupation deny the rights of the Palestinian people to self-determination and amount to systematic racial discrimination and serious violations of international humanitarian law and human rights. Plainly, they cannot be said to be absolutely necessary to meet Israel's own security interests. They serve Israel's other interests, including its goal of acquiring the territory. Mr. President, members of the court, I conclude with the general principle that no state can benefit from its own wrong. Firmly in mind, it cannot be right that, as some states have suggested, the court should refrain from finding that the occupation itself is unlawful or that there is no obligation to withdraw. This would be to allow Israel to profit from its own continued grave wrongs. And to adopt the court's words in Namibia, the court would be failing in the discharge of its judicial functions. Such abdication of responsibility would not encourage or facilitate the achievement of a negotiated solution on the basis of international law. More generally, the court would be sending out a clear signal to other states that they too might be allowed to benefit the prolonged and lawful occupation of the territory of another state. Mr. President, members of the court, these proceedings are a great moment in law. They are a great moment in history. We all have a collective opportunity to develop jurisprudence in a way that advances the cause of humanity. I wish you good luck in your deliberations. Thank you.
I thank the delegation of Pakistan for its presentation. I invite the next participating delegation, Indonesia, to address the court, and I call Her Excellency Ms. Retno Marsudi to the podium.
Bismillahirrahmanirrahim. Mr. President, distinguished members of the court, I left my G20 meeting in Rio de Janeiro to stand before you today on behalf of the government of the Republic of Indonesia to express the solidarity of the Indonesian people on a matter of supreme and grave importance, a matter that strikes at our fragile humanity. I stand before you today to defend justice against the blatant violation of international law that has been committed by Israel. We have all witnessed the ongoing humanitarian catastrophe in Gaza and the following escalation throughout the region, which have emboldened a global call to address the root cause, the illegal Israeli occupation on Palestine. Israel's unlawful occupation and its atrocities must stop, and neither should it be normalized nor recognized. Mr. President, members of the court, it is clear that Israel has zero intention to respect, let alone abide by, its international legal obligation. The Prime Minister Benjamin Netanyahu even said, and I quote, "Nobody will stop us, not The Hague, not anybody else," unquote. This is also evident in Israel's action in Gaza, as it is continuing its indiscriminative campaign of annihilation against civilians in Gaza. Apparently, the death of almost 30,000 lives is not enough for Israel, as it is close to launch another strike on Rafah, once the only gateway for life-saving humanitarian assistance to Gaza. No state should be granted a free rein to do anything they want against weaker state. This is why we have international law. This is why we need to uphold it. The role of ICJ is central to safeguard what the so-called rule-based international order. There is a big hope from the international community. I repeat, a big hope that ICJ delivers a favorable advisory opinion to the interests of justice and humanity. Mr. President, members of the court, the hope is on this court. Against this backdrop, we all assume a collective moral duty to furnish information on the question submitted to the court. Mr. President, members of the court, my statement today will be divided into two parts. First, on jurisdiction, and second, on the merit of the case. First part, on jurisdiction. Indonesia maintains that the court has jurisdiction to render the advisory opinion, and there is no ground to declining to exercise such jurisdiction. This has been clearly elaborated in Indonesia written statement and written comment. Now I will focus on rebuffing the argument of some states suggesting that rendering an advisory opinion would somehow undermine the peace process. While the court has made their opinion clear on this matter, allow me to further stress three arguments. First, there is no viable peace process to be undermined. Israel has been consistently obstructing a negotiated two-state solution. This is in line with international law and relevant United Nations resolution. Israel has even been circumventing negotiation through numerous strategic pretexts. With such strong resistance from Israel to stop its colonial project and its fait accompli unilateral action, no peace process will validly bring a just, lasting, and comprehensive solution. After all, negotiation with someone holding a gun against your head is not a negotiation at all. Despite this rhetoric on peace, successive government of Israel has openly expressed their abandonment of the peace process, including by declaring the Oslo Accord null and void. Just last November, Prime Minister Netanyahu even boasted that, and I quote, "I'm proud that I prevented the establishment of Palestinian state," unquote. It is no wonder that Israeli officials of all levels have been openly ignoring the calls from the UN Security Council to settle this issue peacefully and abide by its international obligation. Along with these attitudes, Israel only has been pursuing a one-sided solution without engaging Palestinians, let alone addressing their interests. Indonesia submits that this confirming Israel has never been interested in any peace process. Second, the request for advisory opinion is not intended to decide on a final solution to the conflict. A comprehensive, just, and lasting solution should only be achieved through direct negotiation between the parties to the conflict, not one imposed from outside or by one party. Rather, the request is intended to seek the court opinion on legal questions asked by the UN General Assembly within its competence. The court should only render its opinion on the legal consequences arising from the ongoing violation by Israel and how they should affect the legal status of the occupation. The questions should be understood as a request for advice to facilitate the General Assembly in devising necessary action within its function. Third, the court opinion will positively contribute to the peace process by presenting additional elements of the law for a comprehensive resolution of the dispute. A genuine and lasting peace process can only be achieved if it is consistent with the international law. Thus, the court opinion is very much needed. By clarifying the relevant legal rules, the court opinion will help in resolving the stalemate that have impeded the peace process. In addition to this positive impact, the court's opinion would be useful to guide the future steps to be taken by the United Nations and all states. Thus, Indonesia submits that there are no grounds to dismiss this request on the basis that it will risk fundamentally delegitimizing any future prospect of peace process. Mr. President, members of the court, my second part is on the merit of the case. Indonesia has made clear its legal argument on the question posed to the court as appeared in our written statement. I will begin with the continued denial of inalienable right of Palestinians to self-determination. In its 2004 advisory opinion on the wall, the court reasserted the Palestinian right to self-determination is no longer an issue. This confirmed the long-held belief of the international community, including as expressed through various UN Security Council and General Assembly resolutions, that the Palestinian people are entitled to self-determination. Let me reconfirm Indonesia's position in line with the court view that the fulfillment of such right is an erga omnes obligation. In other words, all countries, I repeat, all countries have a legal obligation to respect that right and to contribute to its realization. Consequently, any endorsement or recognition of Israel's policies or practices that obstruct the right to self-determination of the Palestinians shall be unlawful. Mr. President, members of the court, in addressing the issue of the right to self-determination to Palestinians, it is also important to remind ourselves that the occupation has become an instrument to suppress such a fundamental right. This court, in its opinion on the wall, as well as the UN Security Council and General Assembly in their resolution, have reaffirmed from time to time the status of Israel as an occupying power. The occupation has been prolonged and enabled by Israel's series of breaches of its obligation under international law, including international humanitarian law and international human rights law. Now allow me to elaborate the following. First, the Israeli occupation is a result of an unjustified use of force. Therefore, the occupation should be unlawful from the beginning and continues to be so. The use of force by Israel could not be justified under the guise of self-defense. It is also in breach of the principle of necessity and proportionality. It is indeed against the prohibition of aggression, a peremptory norm of international law from which no derogation is permitted. Second, the illegal annexation of the OPT. As an occupying power, Israel is legally obliged to keep its occupation temporary. This has been violated by Israel as it has been attempting to make its occupation permanent and also to annex part of the occupied territory. As a matter of law, under no circumstances shall Israel be allowed to annex any part of the occupied territory. The UN Security Council, in its various resolutions, has reaffirmed the established principle that acquisition of territory by war is inadmissible. It is an absolute principle that applies even in circumstances where war has been resorted to lawfully, such as in self-defense, which is certainly not the case of Israel. Israel's transgression to international law does not stop there, as it has declared that Jerusalem is the eternal, undivided capital of Israel. Not only are these actions unlawful, they are also highly prejudicial to the prospect of a two-state solution. Third, continued expansion of illegal settlement. The policy of Israel in transferring its own population and forcibly displacing Palestinians from the occupied territory contravenes the fundamental rules of the international humanitarian law. This policy is a clear violation of the Article 49 of the Fourth Geneva Convention, to which Israel is a state party. It is worsened by Israel's pursuit to change the demographic composition of the West Bank. This policy demonstrates Israel's complete disregard of international law and also shows the intention to make the situation irreversible. Fourth, the apartheid policy against the Palestinians. As an occupying power, Israel is legally obliged to act in the best interests of the Palestinians. Instead, Israel has been reinforcing its prolonged occupation by imposing military orders on the Palestinian population which are not applied to Jewish Israeli settlers. The existence of separate legal regimes that are applied exclusively on different groups of people is a textbook apartheid policy that constitutes a grave violation of human rights, particularly crime against humanity. Having said that, it is clear that the continuation of such apartheid regime is paramount to another breach of a peremptory norms of international law. Mr. President, distinguished members of the court, I wish to elaborate on the legal consequences arising from these policies and practices by Israel. This should begin with respect to fundamental rights of the Palestinian people, particularly the right to self-determination, which has been systematically denied by Israel. The court must pronounce that Israeli occupation is illegal as a whole. It follows that we must bring this illegal situation to an end. Israel must cease completely, unconditionally, and immediately all of its unlawful action and policies in the occupied Palestinian territory. With the continued presence of Israeli forces in the West Bank and Gaza, it is impossible to see Israeli compliance with its obligation. Thus, it is imperative that Israel must withdraw its forces. Given the illegal nature of the occupation, Israel's withdrawal must neither be done with precondition nor subject to any negotiation. They must withdraw now. I repeat, they must withdraw now. Israel should also be obliged to make reparation both to the state of Palestine as well as to the Palestinian people. Mr. President, please allow me to recall a legal maxim which states that no one may enjoy legal benefits from illegal action. Therefore, Israel's attempts to make its occupation permanent shall never be a valid ground to claim a legitimate title over the Palestinian territory. In line with this, all states and the United Nations must not recognize the illegal situation arising from the violation of international law by Israel. All states must not render any assistance to the maintenance of such violation. Moreover, all states and the United Nations should also ensure Israel's compliance with its obligation under international law. Mr. President, members of the Court, I would like to conclude by underlining that no country is above the law, that no country is above the law, and the sanctity of this court must be upheld. Indonesia believes that this legal motion is also a motion of global conscience. It should not be another item on the list, another proceeding to dismiss, another call to go unheeded, ignored blatantly by Israel. Never again means never again. We founded our current international system with the conviction that every single human being, I repeat, every single human being, without exception, is protected by law. Every single human being, without exception, is protected by law. Thus, let us all contemplate upon this question. Should the international community continue allowing Israel to manipulate the use of international law to justify its illegal action against the fundamental rights of the Palestine? For Indonesia, we shall not. And once again, the hope is on this court, as the court is the guardian of justice. I thank you very much.
I thank the delegation of Indonesia for its presentation. I invite the next participating delegation, Qatar, to address the court and call upon His Excellency Mutlaq Al-Qahtani to take the floor.
Mr. President, members of the court, it's a great honor to appear before you as the representative of the State of Qatar in these historic proceedings. Qatar believes firmly that it's only through full respect for international law that peace and justice can be achieved. Recent events have underscored that international legal order is under threat. Unprecedented violence, hatred, cruelty risk undoing decades of progress in the field of human rights, humanitarian law, and the peaceful settlement of disputes. Indeed, there is growing perception in some quarters of the that international law applies to some, but not to others. That some people are seen as deserving of security, freedom, and self-determination, but others are not. Some children are deemed worthy of the law's protection, but others are killed in their thousands. Qatar rejects such double standards. International law must be upheld in all circumstances. It must be applied equally to all, and there must be accountability for all violations. Yet, more than 75 years, the right of the Palestinian people has been treated as an exception to the international rule of law. Mr. President, members of the court, you have the clear mandate and indeed the responsibility to remedy this unacceptable situation. The credibility of the international legal order depends on your opinion, and the stakes cannot be higher. Indeed, Israel's genocidal war on the people of Gaza has shown that the situation in Palestine is the most pressing threat to international peace and security. As Secretary General Guterres emphasized, recent events did not occur in a vacuum. Rather, they grew out of Israel's illegal 57-year occupation of the Palestinian territories. Israel has denied the Palestinian people's right to self-determination. It has ethnically cleansed and colonized Palestinians' lands. Furthermore, it has implemented an apartheid regime, that's to say, a regime of systematic racial oppression and discrimination established with the intent to maintain the domination of Jewish Israelis over Palestinians. To maintain that regime, it has killed, maimed, and imprisoned tens of thousands of men, women, and children. These are the root causes of the situation we face today. These same causes are the subject of the General Assembly's request for advisory opinion. 20 years after its historic wall opinion, the Court now has the entire question of Palestine squarely before it. The General Assembly did not mince its words when it posed two clear and complementary questions. Question A calls upon the Court to assess the legality of Israel's individual policies and practices in its occupation of the Palestinian territories, which I will refer to as the OPT. Question A further calls upon the Court to state the corresponding legal consequences of each of these policies and the practices. Question B, in turn, asks the Court to answer a simple but historic questions in light of numerous illegalities in the conduct of the occupation. Has the occupation itself become illegal? If the answer to that question is yes, which is Qatar's submission, then the consequence is obvious. The occupation must be brought to an end. Mr. President, members of the Court, Qatar's intervention will cover three topics. First, I will briefly explain why the Court should give the advisory opinion requested by the General Assembly. Second, with reference to question A, I will recall Israel's main illegal policies and the practices in the OPT and explain that they are not isolated or accidental, but they are part of Israel's longest-standing settler colonial project in Palestine. Third, and finally, I will set forth Qatar's position on question B concerning the legal status of the occupation. I turn now to my first topic, propriety of the Court rendering the advisory opinion. Mr. President, I need not to repeat what you have already heard from numerous participants this week. The Court unequivocally has jurisdiction, and there is no compelling reason for it to refuse to give its opinion. In particular, the Court's opinion would not underestimate or undermine the possibility of a negotiated solution to the conflict. Qatar explained why, in its written comments, the so-called peace process is dead. To provide the Court with relevant historical context, Qatar engaged two most prominent historians of the Israeli-Palestinian conflicts alive today. One Palestinian, Professor Rashid Khalidi of Columbia University, and one Israeli, Professor Efli Shalim of Oxford University. Professor Khalidi and Shalim prepared two comprehensive reports covering a century of histories from 1917 to 2023. You can find those reports at tabs 2 and 2 of your folders. Professor Shalim's report is devoted to the history and diplomacy of the Israeli-Palestinian conflict from 1967 until today. He explains how, during this time, Israel has consistently obstructed a negotiated solution. Rather than pursuing a genuine peace, Israel used the so-called peace as a diplomatic cover for its colonization of Palestine. In this context, it's difficult to see what harm the Court's advisory opinion could possibly have on a non-existent peace process. On the contrary, the absence of a viable peace process only underscores the necessities of the Court's advisory opinion and a solution based on international law. I turn now to my second topic, concerning question A and Israel's illegal policies and practices of the OPT. Mr. President, members of the Court, Israel's illegal and discriminatory policies and practices are the tools of long-standing settler colonial project. As Qatar explained in its written statement, these policies are designed to promote a single goal: the permanent colonization of the OBT for the exclusive benefit of Israel and the Jewish Israeli settlers. This goal is essentially linked to Israel's oppressive and discriminatory practices in the OBT and is the root cause of the cycles of violence there. In Chapter 2 of its written statement, Qatar described in detail the 8 main categories of discriminatory policies and practices that Israel employs in furtherance of its settler colonial project. In Chapter 3 of its written statement, Qatar explained that these policies and practices entail a flagrant violation of international law, human rights law, and constitutes a crime against humanity, war crimes, genocide, and ethnic cleansing. It is Qatar's position that in order to fully respond to question A, the court should assess the legality of each of Israel's main policies and practices through these lenses. A fulsome response to question A is no less than a clear answer to question B. The court should not underestimate that the impact that finding of fact and law will have in bringing Israel's specific policies and practices to an end, to encouraging accountability, and to provide victims with a sense of justice. In the limited time I have today, I will briefly call some specific points about the 8 main categories of policies and practices carried out by Israel in the OBT. The first central features of Israel's settlers' colonial project is, of course, settlement. The establishment and development of Jewish Israeli settlements in the OBT began immediately after Israel occupied it in 1967. Israel establishes Jewish Israeli settlements on seized Palestinian land, finances and facilitates the construction of housing and infrastructures, and incentivizes Jews from around the world to settle there. By 2023, over 700,000 settlers, or approximately 11% of Jewish Israelis, were living in the OBT. The settlement's activities is relentless. In a January 2024 report, which you can find at tab 3 of your folders, the Israeli human rights group Peace Now explained how the war in Gaza has been exploited as cover for unprecedented surge in settlement activities. The same is happening in East Jerusalem, and even Gaza is now at risk. The Israeli security ministers recently stated that, quote, "Not only do I not rule out Jewish settlement in Gaza, I believe it is also an important thing," end quote. On January 28, 2024, a conference dedicated to the resettlement of Gaza was held in occupied Jerusalem, which was attended by 12 Israeli government ministers. Mr. President, members of the court, let me pause here to make a brief remark about the situation in Gaza as it relates to the advisory proceedings. The contentious proceedings instituted by South Africa against Israel under the Genocide Convention do not mean that the recent situation in Gaza should not be addressed here. Gaza is part of the OBT. It was occupied before October 7, and it is occupied today. Israel's policies and practices referred to in question A includes its policies and practices in Gaza. The court will examine the situation in Gaza through the lens of the Genocide Convention in the case brought by South Africa. Here the court can, and indeed must, apply all aspects of international law to the situation in Gaza, including well before October 7. This brings me to Israel's second central policy and practice in the OBT, which is displacement. In order to establish its settlements in the OBT, Israel seizes public and private land and forcibly displaces Palestinians. It does so through home demolitions, evictions, building restrictions, and by establishing buffer or military zones. Again, the situation has only grown worse since October 7. As is well established, Israel had forcibly displaced at least 75% of the population in Gaza. This policy is promoted by Israeli leaders as a solution to their Palestinian demographic problem. Israeli Minister of Culture stated that the Palestinians, quote, can go to island or to the desert. The masters in Gaza should find a solution by themselves, end quote. While all eyes may be on Gaza, the situation in the West Bank is rapidly deteriorating. At least 13 different communities in the West Bank have faced forced displacement since October 7. That has resulted in the north-south stretch of 20 kilometers east of Ramallah being cleared of nearly all Palestinians. The third Israeli practice is fragmentation. In order to implement the demographic and physical control necessary to perpetuate the occupation and establish further settlements, Israel divides and isolates Palestinians. It relegates them to fragmented enclaves, restricts their movement, and renders their daily lives all but unlivable. This is what Namibia and Belize aptly referred as strategic fragmentation. Israel has imposed a full blockade on Gaza since 2007, entirely cutting its population off from the rest of the world. October 7, Gaza had already been described by the UN Secretary General as hell on earth. Today, it is indescribable. In the West Bank, Israel has, for decades, implemented a system of draconian checkpoints, subjecting millions of Palestinians to daily indignities. Human Rights Watch has documented, quote, more than 40 kilometers of West Bank roads that authorities prohibit Palestinians from traveling on, end quote. Since October 7, Israel has implemented unprecedented lockdown on the entire civilian territory of the West Bank. It has closed much of its vast network of checkpoints, completely cutting off cities, towns, and villages from each other. The fourth practice that characterizes Israel's occupation is its discriminatory and unlawful violence. Israeli forces and Jewish Israeli settlers, often with the support of the state, use violence to crush even non-violent resistance to the occupation and to perpetuate a climate of fear and repression. Israeli violence has been part of the fabric of life for Palestinians even before the beginning of the occupation in 1967, and Gaza has always paid the highest price. In the 15 years before October 7, Israeli military campaigns killed 5,365 Palestinians in Gaza, the majority of whom were indisputably civilians. Of course, this is shocking statistics pales in comparison to what we have in the past 4 months. At the same time, the court cannot ignore the ever-worsening situation in the West Bank. Since October 7, 397 Palestinians have been killed across the West Bank, and 453 have been injured. Even before October 7, 234 Palestinians were killed in 2024, which was the highest number on record. Civilian casualties are not just collateral damage in Israeli attacks. They are the main target. The use of warplanes, armed drones, attack helicopters, and missiles was once unprecedented in the West Bank. Now it is routine. Mr. President, members of the court, Israel's victims are often children. They include 5-year-old Ruqayya, who was shot in the back by Israeli forces on January 7th at a military checkpoint in the West Bank. Her body was withheld from her family by Israeli forces for 10 days. Just last week, Israeli forces also shot 16-year-old Nahil in the head, killing him as he was leaving school. Nahil was the 100th Palestinian child killed by Israeli forces in the West Bank since October 7. This brings me to the fifth practice implemented by Israel, which is its discriminatory military legal system in the OBT. This system privileges Jewish Israeli settlers while depriving Palestinians of the most basic legal protections. A pillar of this system is the practice of indefinite administrative detention of Palestinians without charges. As we detailed in our written statement, this practice was widespread before October 7. Its use has increased excessively since then, in what some rights groups have characterized as mass enforced disappearances. In the past 4 months alone, thousands of Palestinians have been placed in administrative detentions. In Gaza, they are rounded up, blindfolded, disrobed, humiliated, and detained in mass makeshift outdoor prisons. You can find detailed reporting at tabs 5 and 6 of your folders. In the interest of time, I will not detail the 3 remaining policies and the practices that characterize Israel's occupation, which are discussed in Chapter 2 of Qatar's written statement. These practices are 6: the eradication and suppression of all manifestations of Palestinians' culture and religion in the OBT. 7th, the economic oppression of Palestinians and the exploitations of the OBT's natural resources. And 8, the systematic persecution and suppression of all those who attempt to document or pursue accountability for the occupation, such as human rights organizations and journalists. This includes Al Jazeera, Shireen Abu Akleh, who was murdered by Israeli forces on May 11, 2022. Mr. President, members of the court, these 8 discriminatory practices and policies are among those that the court is called upon to assess in answering question A. Viewed jointly, they reveal the true nature of the occupation as an illegal settler colonial regime. I will turn now to the final portion of Qatar's presentations concerning the legal status of the occupation and the response to question B. Mr. President, members of the court, the written statements and comments that addressed in question B overwhelmingly endorsed a finding by the court that the Israeli occupation of the OBT is illegal. This was the express conclusion of at least 38 participants in these proceedings, with at most 2 states reaching the opposite conclusion. Those participants finding that the occupation is illegal offered a number of lines of analysis to support their shared conclusion. This is unsurprising. Israel's occupations has violated so many fundamental principles of international law that it would be hard to point to just one reason for its illegality. In Chapter 3 of Qatar's written comments, we identified 5 main reasons as to why Israel's occupations of the OBT is illegal. With its written comments, Qatar also submitted a detailed appendix compiling relevant statements by participating states and organizations. These can be found at tabs 7 to 15 of your folders. We hope that Qatar's analysis will be helpful for the court's work. I shall briefly walk the court through 5 reasons for the illegality of the occupation. First, the occupation contravenes the Jus Cogens obligation to respect the right of self-determination of the Palestinian people. 39 states and international organizations found that the occupation violates the right of self-determination. 28 of those participants underscored that the occupation has become illegal for this reason. Second, Israel's occupation also violates Juskogin's prohibition of apartheid. 25 participants endorsed a finding of apartheid. Among those reaching this conclusion, 16 participants underscored that the situation of apartheid renders the occupation itself illegal. Third, Israel's occupation is illegal because it violates Juskogin's prohibition on the use of force. This was the conclusion of 18 participants. Fourth, by virtue of its illegal annexation of portion of OBT, Israel has breached yet another Juskogin's norm, the prohibition on the acquisition of territory through the use of force. At least 41 participants in the proceedings have pointed this out, with 31 of them underscoring that the occupation is illegal as a whole because Israel's annexation of the OBT is an integral feature truth, justice, and yes, reconciliation. Mr. President, members of the court, the people of the world are looking at you. We are confident that you will seize this historic opportunity to finally bring to an end a century of injustice against the Palestinian people. I thank you for your kind attention.
I thank the delegation of Qatar for its presentation, which brings to a close this morning's hearing. The court will meet again this afternoon at 3 p.m. to hear the United Kingdom, Slovenia, Sudan, Switzerland, the Syrian Arab Republic, and Tunisia. The sitting is adjourned.